Back on the right stand with the update that the Allahabad High Court has dismissed a plea filed by the Anjuman Intizamiya Mosque Committee against the Varanasi court order that said that the Hindu side plea of seeking the right to pray inside the Gyanvapi Mosque Parisar at the Shringar Gauri area, that is maintainable. The High Court order means that Allahabad High Court has upheld the maintainability of the Hindu side's plea. Hindus have been demanding the right to pray to the Vigrahas or the Murtis that have been kept inside the Gyanvapi Mosque complex. Let's try and go across to Vishnu Jain joining us live. Vishnu Jain, can you take us through what happened and what was the argument? And this hearing in the High Court, was it scheduled or is it a process since all matters now with respect to Gyanvapi are being heard by the Honorable Allahabad High Court?
It has originated from judgment passed by the Honorable Trial Court on 12th of September. As you know that on 12th of September, the District Judge Varanasi had held that this case is not barred by Places of Worship Act and Waqf Act. Aggrieved by that order, the Anjuman Intizamiya had approached the Allahabad High Court, and Allahabad High Court had 20 hearings. 20 hearings had happened before the Allahabad High Court, and today by judgment of single judge bench, the Allahabad High Court has dismissed the petition filed by Anjuman Intizamiya and has held that Places of Worship Act and Waqf Act is not attracted in this case. So now the consequence is that we will be allowed to raise our other demands so far as ASI of the entire area is concerned, so far as leading of evidences is concerned by way of historical evidence, by way of Shastric evidence, by way of gazetteers, by way of travelogues. And apart from that, all other oral evidences will be led before the Honorable Varanasi Court. The evidences will be, after seeing the evidences, issues will be framed and ultimately the court will pass their verdict.
So in this case, even though the plaintiffs had come out and said, the 5 ladies had said that we should be allowed to pray on a daily basis. Now, will that be allowed or is it status quo as of now?
See, our plea has been a very systematical plea. As per CPC, first you have to file a civil suit before the court. After filing the civil suit, the first step which has to be done by any civil court lawyer is to ask for commission to bring the actual spot position before the court. Now that report is before the court. Now the next step is to have an ASI of the entire area. After the report of the ASI, we will definitely ask for an interim relief seeking a right to worship on the entire premises. And I must tell you that we had a very clear case that till November 1993 we were worshipping in the premises in question. In this present proceedings which Allahabad High Court has passed its verdict, the Additional Advocate General of UP government, Mr. MC Chaturvedi, he was asked by the Honorable Court that whether there is any oral or written order by which this puja was stopped and installed. And his reply was that there is no oral or written order by which this puja has been stopped and installed. So it is a very clear fact that Mulayam Singh Yadav in November 1993, he made barricading in the entire premises and he stopped the puja of this entire premises, which was an illegal act, and our fundamental rights were eclipsed and were diminished. Against that illegality, we have approached the court and we have asked that in the entire premises, puja part must be allowed to be done. And our right to worship petition commission report has come in this petition. The Honorable Allahabad High Court has said that Shivling must be investigated by the ASI. The matter is drawing attention of the Honorable Supreme Court, and the hearing is fixed on 6th of July. We will argue our points before the Supreme Court on 6th of July. On 7th of July, the matter is fixed before the Trial Court of Varanasi, where we have asked for ASI of the entire area except the sealed area. So that will be heard by the District Court of Varanasi. And then after the report of the ASI, issues will be framed, evidences will be led, and then the judgment of the Honorable Court will be delivered.
So it still has, this entire matter still has various legs and various aspects in terms of the case. I want to understand what happens next. The next hearing is what? The hearing in the Honorable Supreme Court on the ASI survey? Is that what?
Now let me tell you certain recent developments. All the cases, we had filed 6 cases in the Varanasi Civil Court, which is not just of puja, which is of title also. And all the 6 cases have been transferred to the District Court of Varanasi. All the 6 cases have been clubbed. And now we have asked for the ASI of the entire area, which will be heard by the District Court of Varanasi on 7th of July. So far as the ASI demand of Shivling is concerned and a scientific investigation of Shivlingam is concerned, that will be heard by the Supreme Court on 6th of July. So these are the things which are going to upcoming in this present case, and we are preparing and we are looking forward to make our contentions and arguments before the Honorable Court.
You've said that the month of May has been very productive for the Hindu side on 2 aspects. the Gyanvapi and also the Krishna Janmabhoomi aspect. I've just come across your tweet.
Yes. See, I have tweeted on the basis of legal history of this entire month of May. On 1st of May, the issue of maintainability was decided by Honorable Allahabad High Court, which was pending from past 1.5 years. On 12th of May, the SI investigation of Shivling was ordered by the Honorable Allahabad High Court, which was also pending from 14th of October 2022. Then on 26th of May, the Honorable Allahabad High Court has directed transfer of all the cases of Krishna Janmabhoomi for original trial to Allahabad High Court, which is very massive and very huge. And apart from that, on 31st of May, the Honorable Allahabad High Court has upheld the maintainability of our suit. So all these efforts have been taken from trial court to Honorable Allahabad High Court, and I am very happy with the legal team which I have, and I am very happy with the support with all the petitioners. They believed in us and our arguments, and all those arguments which I have raised on your channel and on various platforms, that arguments have ultimately resulted into findings of court. So we are very happy, and we will support our arguments and contentions before the Honorable Supreme Court.
Now, on this maintainability aspect, with the challenge of the Anjuman Intizamiya, do they have the option of knocking the doors of the top court of the Supreme Court?
Definitely, against this order, they can file a SLP under Article 136 of the Constitution of India, and I think perhaps they will do so also. And we are also ready. We will file our caveat before the Honorable Supreme Court. We will make all our contentions and arguments before the Honorable Supreme Court. I have a very simple case that this case is not barred by Places of Worship Act. Rather, this case is a blatant violation of Places of Worship Act, because Places of Worship Act has been enacted in 1991, while the fact of the matter is that in November 1993, the Vyas Parivar was doing puja beneath the cellar, in the cellar, and on western wall of the so-called mosque we were worshipping, and on various parts of the so-called mosque, various portions of the so-called mosque we were worshipping, which was illegally and completely in violation of the Places of Worship Act. The then government had ousted it from the possession of the property, and therefore it's a clear violation of Article 25, and we will raise all these contentions.
So you have photographic evidence of 1993, and today you have said in court, the Advocate General of Lucknow of the UP government has said that there is no written order.
No written order. I am saying it with utmost sense of authority on your channel, that there is no written order or oral order by which the puja of Ma Shringar Gauri, which happens on the western side of so-called mosque, is stalled. And till date, we are able to touch our vigre, we are able to do puja on the western side of so-called mosque only on one day, that is on the 4th day of the Navratra, which happened this year also. So I am asking a question, that are we living in a constitutional country? Is this constitutional? Is this legal? Has any authority right to stop puja without any written order, without any oral order, just by their whims and fancies? Like this, can you play with the beliefs and faiths of thousands and crores of Hindus? And therefore, we have approached the court of law, rightly so, saying that our right under Article 25 has been infringed, and this suit is for enforcement of our rights under Article 25.
Right. Vishnu Jain, thank you very much. You are anticipating that the Muslim side will move the top court and that you will file a caveat so that your part is also heard. The next scheduled hearing on these matters is on the 6th and 7th of July in the Supreme Court and in the District Court respectively. We will continue to track the developments. Thank you very much for your time, Vishnu Jain. Namaste.